University of London as well. He'll be sharing some thoughts with us. He's been a visiting lecturer at the Ghana Commercial Bank Training School. He's facilitated a number of training programs in other banks as well. He's a banking law and practice lecturer at the Chartered Institute of Bankers since 2017. He's also a regular columnist in the Golden Eagle, which is GCB's in-house newsletter, and the list goes on and on and on. He's managed several branches of GCB. He's headed the central operations at GCB also, and he formerly was the head of consumer banking in 2017, I beg your pardon, before he was elevated to becoming the executive head of retail banking at GCB. My guest for this afternoon is John Adama. John, you're welcome to the conversation.
Thank you very much, Yao.
I'm excited that you're here. Yesterday we spent a few minutes trying to catch up as we prepared for this conversation this afternoon.
Yes.
And I said that, when I hear the topic for the conversation, I know straight away what the reaction is going to be like, because it speaks to a concern that many people have today.
Yeah.
And I know when we get interactive, we're going to get a lot of hits, both on social media and also on other channels.
Yeah.
If you're watching us or you've just joined in, this is Masterclass here on your Superstation. We will be getting interactive at some point. But when you lose a loved one and you have to go to the bank to go through the processes of claiming their credit balances so that you can even put together a decent funeral for them, what are the challenges that you go through? What has your personal experience been? When we open those phone lines, we want to get interactive and you share your thoughts with us. But before that, we're also streaming live on Facebook. Go to our Facebook page. For those of you who like to watch along as listen, you'll be able to watch what's going on here in the studio. John, that sort of sits in the soul or at the center, if you like, of the concerns that people have when they go through the unfortunate experience of a demise of a loved one.
Yeah.
But today we're going to be sharing some processes with them, some steps they can go through.
Yes, please.
And hopefully, with this new information, it will make the experience much better.
Sure.
Right.
And I'm excited to be here.
We're excited to have you, John.
Thank you.
So perhaps we'll just introduce the conversation, maybe from a very early stage.
Yeah.
What happens? What are some of the things that people should begin to look out for?
Okay.
Immediately there's a demise.
Okay.
And you're aware.
Okay.
And then sort of take us through.
Okay.
I've seen your slides, very extensive.
Yeah.
So let's just go through the content.
All right. Thank you very much. I think we'll begin with what happens to the relationship between a banker and a customer when the customer is deceased. I think that should be the starting point. Right. The relationship between a banker and his customer is contractual. And by the terms of that contract, the bank is expected to discharge certain obligations to the customer. One of those obligations is that when the customer makes an order for payment, the bank must honor that order. That order, that instruction given by the customer to the banker is what we refer to as mandate. So in that sense, the bank becomes the mandatory and the customer becomes the mandator. And the mandator is enjoined by the terms of the contract to honor the instructions of the mandatory. However, there are certain circumstances that would make it impossible for the banker to discharge the mandate. And one of those circumstances is what we are going to talk about, and that is death. So death determines the mandate. And when we say death determines the mandate, it means that once your customer is deceased, until some further steps are taken, that customer's account cannot be debited. And we have a statutory basis for that. If you look at the statute regulating payments, check operations generally, the Bills of Exchange Act 1961, Act 55, Section 74B of that statute provides clearly that the banker's authority to make payments or to pay a customer's check is determined by death. And that is why when your relative dies and you walk into the bank and you want the bank to debit that relative's account and pay out, the bank is unable to do so because that is part of the terms of the contract. So one of the exceptional circumstances under which the bank would set aside the mandate or will not obey the mandate is when there is death. And so that is why it is important that listeners would know the processes that they would have to pass through before they can claim those credit balances. And I think that is what we want to look at. But to situate this conversation properly, we would have to look at various types of accounts that a bank can keep for a customer. And so we would, in no particular order, a customer can have a personal account. So one person, an individual, you open your account, you operate it. Unless, of course, you have granted a power of attorney to someone to operate on your behalf, you are the one who would operate that account. So that is an individual's account. Then we can also have an account that is operated by two individuals, two or more individuals. And that is what we refer to as a joint account. The treatment of deceased customers' balances will differ from account to account. And that is why I'm laying this foundation. So how an individual's account balance will be treated will be different from how a joint account balance will be treated in times of death. So that's why I'm laying this foundation. Right. Then we also have a sole proprietorship. A sole proprietorship is a business organization that is registered by one person in a business name. So if I want to operate a business and I don't want to use my surname and my first name, I could register a business name and have exclusive rights over that name, and I will operate my business in that name. An account opened for that type of business is a sole proprietorship. But the sole proprietor in law is just the same as the sole proprietor. A sole proprietorship is the same as a sole proprietor.
So the owner is the company and the company is the owner.
Exactly. And yeah, so there is no separate legal personality issues about a sole proprietorship. The sole proprietor and the sole proprietorship are one and the same. Then we have a partnership. Partnership is an association between two or more persons who carry on business jointly with the purpose of making profits. And if you look at the Partnership Incorporated Private Partnership Act, you can have two partners and you can have a maximum of 20. So it can be 2 up to 20. And when that business is registered, it assumes a separate legal entity, separate and distinct from the partners. I'm saying these things because when, in times of death, if it's a partnership, there is a separate treatment. That is why I'm trying to explain the different types of businesses. So a sole proprietorship can have a sole proprietorship account with the bank. There could be a joint account at the bank. There could be a partnership account at the bank. And then we have the limited liability companies. And after incorporation, a limited liability company assumes a distinct personality, separate from the shareholders who are the members of the company and the directors who are the directing minds of the company. And so if you look at a company, the members of the company who are the shareholders and the directors who may or may not be shareholders are not the same as the company. So if a shareholder dies or a director dies, the Companies Act provides for how a director could be replaced, or when a shareholder dies, what happens to the shareholding of that shareholder is provided for. And so death for a company may be different from death in the case of a sole proprietor. So we'll look at when we come to treatment of the balances, we'll look at them from that perspective.
And for me, I think that distinction you've just made is absolutely important.
Yeah.
So that people should understand if your beloved person who has just passed was the owner or MD or shareholder of a company, let's say majority shareholder, and he's passed, you don't walk into the company and start throwing your weight around.
Exactly.
There's a separate treatment.
Exactly.
If he was a sole proprietor, he owned the business alone. He didn't own it with anybody. It was not limited liability. It was not a partnership. The treatment is also different. And in this conversation,
we'll clarify, we'll highlight all of them.
Brilliant.
Yes.
Brilliant.
So having laid that foundation, we can start from the, let's start with a sole proprietorship. So when a sole proprietor dies, as we have indicated, the sole proprietorship and the sole proprietor are one and the same. And so when a sole proprietor dies, the account balance will form part of his estate. And when I say estate, I'm referring to the movable and the immovable properties of a deceased. So
including the ones that people don't know about.
Yes, including those that they don't know about. They all constitute, if you look at the Administration of Estates Act, it defines all of them as the movable or the immovable property and of the deceased. So the account balance forms part of the estate. And so if a sole proprietor dies, for instance, the sole proprietorship by operation of law should have come to an end. So death of the sole proprietor marks the end of the sole proprietorship. So, but account balance devolves to the personal representatives of the deceased sole proprietor. And we'll come to explain who personal representatives are. Okay. Yes. So the balance on the sole proprietorship account devolves to the personal representatives when the sole proprietor is deceased. Now, when we take a joint account, before we come to partnership, we take a joint account. Joint accounts, as I've explained, are accounts that are operated in the individual names of 2 or more persons. So if you and I, Yao and John, open a joint account, so the account will be John and Yao. We have not registered a business. It's just a personal account, but in this case it's 2. The mandate on that account could be either to sign, which means that I can go and sign and withdraw mandate account, and you could do same. Or it could be both to sign. Maybe I don't trust Yao that much. So, and Yao also doesn't trust me that much. So before withdrawals could be made from that account, both of us must give the bank a mandate. So both of us must sign the instrument that will be used to do the withdrawal. Now, when one of us is deceased, in law, the credit balance on that account would devolve to the survivor without any recourse to the personal representatives of the deceased.
Okay, I like this point you've just made.
Yes.
Let's repeat it, and I'll try and rephrase it in plain English for my listeners.
Okay, all right. So the point I'm making is that if 2 or more parties operate a joint account, and which joint account I have explained to be an account in the individual names of 2 or more persons. Now, if one of them is deceased, the credit balance on that account would pass on to the survivor or the survivors. So if you are 3 parties to the joint account and one is deceased, the credit balance on that joint account would pass on to the 2. The deceased's personal representatives would have no claim.
No locus.
No locus. Yes, as the lawyers would say.
John, it's important, this point you've just made.
Yes.
And for those of us who are listening this afternoon, you need to understand this. Because sometimes you hear, and my husband had a friend, and they were doing some business together, and he passed, and the guy has taken the money.
Yes.
He's taken the money because the law provides that if the account was opened in their 2 names, if it was a company, it's a different
That's a different issue, yes.
In their 2 names, and the mandate was either one to sign or both to sign, and one passes, your beloved passes. By law, if it's $1 million in that account, it goes to his partner. It is not your husband's money, or your wife's money, or your brother's money.
Yeah.
Understand that. It's absolutely important. That's why we're taking time to share this.
Yes.
It's a very important point you're making, John.
Yes. And Yao, that ties into a point you raised, I think, during our conversation yesterday. Now, you've raised the issue of the relatives of a deceased being in limbo financially when the breadwinner passes on. I think that we should be learning to open joint accounts. Even if we have our own accounts, let's keep some small joint account on the side. So if I have a joint account with my wife, and the unfortunate happens, and I'm not there, I'm the breadwinner, by the operation of the survivorship clause, which is embedded in account opening forms of all banks, the credit balance will pass on to my wife. So my wife will not be cash strapped if there is money in that joint account. So whilst waiting to process documents that can entitle them to my estate, they could have some cash, because my wife can draw from that joint account to keep the home going.
It's important, and let's clarify.
Yes.
We're going to come to the lessons of administration bit.
Yes.
If it's a limited liability company, or if it's any other thing, you can only access it.
Yes.
Or let's say the account was only in your husband or wife or brother's name alone.
Okay.
You can only access it as surviving estate after letters of administration and process have been gone through.
Sure.
what you are advising them to do,
yes,
our listeners to do,
yes,
is to have a joint account.
Yes.
By joint account, you don't need to wait for letters of administration.
Exactly.
You don't need to wait for the moment the demise happens.
Yes.
By law.
Yes.
As the second person or as a joint person in the account.
Yes.
You have access to the funds.
Yes.
So talk to your brothers, your wives, and your husbands.
Yes.
And if you are planning for the future, God knows. I mean, thank God we're all going to live very long.
Yeah.
But because of your children and your surviving estate, and by this I mean either wife or husband.
Yes.
Put some money somewhere where
exactly.
the other person has access to. Somebody said to me, I have some money somewhere. It's not in any bank anywhere, but it's in some corner of the house. And I've told this person that the day something happens, you can go to that money.
Yeah.
Whichever way you want to approach it.
But that money is at the mercy of anyone.
Anyone.
Because anyone could break into your house and take the money.
But
if you open a joint account. Yes, and place it there.
Yeah.
I mean, when you are not there, at least in the interim, there is some
immediate
liquidity
to work
in the home.
Thank you so much for that point, John.
Yes.
Let's continue.
So that's for a joint account.
Yes.
And partnership. When a partnership account is operated at a bank, and a partner dies, the death of a partner does not mark the end of the partnership. That is the law.
If a company registered as a partnership.
Yes, if a business registered as a partnership.
The death of a partner
does not necessarily mean that the partnership must be dissolved. So if the partnership has an account, the mandate may not be determined. I don't know if that point is clear.
Meanwhile, in the sole proprietorship, the death of the sole proprietor marks the end of the sole proprietorship.
Yes, it marks the end of the sole proprietorship and determines the mandate. In fact, it terminates the mandate that has been given to the bank. If any checks were presented on that account, it will not be paid.
Until the
right processes are gone through, which will come through at the end of the, towards the end of the program. So with a partnership, when a partner dies, if the members fall below the statutory 2, I told you that a partnership could be 2 up to 20. Yes. So if the numbers fall below 2, then the existing partner would have to take steps to admit another person into partnership. And once that person is admitted into partnership, whatever mandate they have given to the bank, if the mandate required the deceased partner to have been signing, they can easily replace him. So that account is not in jeopardy if it is a partnership. So the issues about I need letters of administration to be able to obtain credit balances on a partnership account will not arise.
Because all that requires to be done is for the partner to be replaced through due process.
Through due process.
And the privileges that accrued to the demised partner now transfers to the new partner.
His interest may not necessarily transfer to the new partner.
Okay.
I mean, every partner has an interest in the partnership.
Okay.
You have contributed money or money's worth into the partnership. So your interest is in the partnership, which could be claimed by your personal representative.
Right.
But in terms of the legal status of the partnership, it will not end with the demise of that partner.
Right.
So the other partners can reorganize. And if there are even more than 2, if the death of the partner does not reduce the numbers below 2, the surviving partners could continue to run the business.
Right.
So the account balance will not be in jeopardy, and nothing need actually to be done to the accounts. So the mandate may not be determined, unless, of course, the partner who died signs, for the bank to carry out instructions. If that was the case, then he must be replaced.
And that right of signing will transfer?
Will transfer, yes. The partnership can appoint anyone.
But just to be clear, what we are saying is that the business of the partnership can continue.
It can continue.
We are not saying that the surviving estate of the demised can have access.
No.
I just wanted to make that very clear.
Yes.
Right.
Because as we said, a partnership is not it's not like a sole proprietor where you would say that you own it absolutely. Yes. Because you have an interest, some other people also have an interest in that business.
Brilliant.
Okay.
Brilliant.
Now let's take limited liability companies. And this is an area that had come up several times. I mean, you have people asking you, so when the sole shareholder of a company is deceased, what happens to the account that is maintained at your bank? And these things have come up several times. Now, there's a long line of cases that establish the separate legal personality principle of companies. And Solomon versus Solomon and Co. Even in our own Supreme Court, Boko versus Kuma, and all those line of cases, they establish the fact that a company once incorporated is separate and distinct from the shareholders and from the directors. And so if you are even the sole shareholder of the company, and if you look at the Companies Act, Section 6 of the Companies Act, 2019 Act 992, it will tell you that one or more persons can form a company. Now, all that you need to do is to comply with the requirements of the code, of the Act. And then, if you go to Section 171, a company must have a minimum of 2 directors. So what it means is that I can form a company being the only member of the company. All I need to do is to get 2 directors. So once that is done, the company is formed, and the company is separate and distinct from me. Even if I'm the chief executive officer, I am the sole shareholder, and I'm also a director. My multifaceted role in that company will not make the company my alter ego. I mean, the company will not be the same as me. We are separate and distinct. Now, with that point in mind, if the single shareholder, let's say you have a company and we have several one-man companies around, if the shareholder dies, the company doesn't die.
As is the case in partnership.
Partnership. The company doesn't die. In fact, even in this case, it's even more pronounced than in a partnership. So if I own the 100% of the shares in the company, and I'm one of 2 directors, if I die, the company will still continue to exist, operate, because it has perpetual succession. All that the Act says is that a company cannot operate without a member. So if I die, I'm the only member. In fact, shareholders are the members of the company. They are the ones that are entered in the register of members of that company, and they are the shareholders of the company. So if the shareholder dies, let's say the only shareholder of the company, 100% ownership, he's deceased, and he's also one of 2 directors, there will be 1 director. Now, what will happen is that that shareholder may be inherited. There will be personal legal representatives of that shareholder. And if you look at Section 102 of Act 992, they are the ones who can inherit the shareholding of that deceased shareholder and get registered as members of the company. So the company continues. Now, if the directors are reduced to 1, the death of that shareholder director has created a casual vacancy in the number of directors.
Right.
The Act vests the existing director with powers to appoint a director to make up the numbers. Or the company itself, by a resolution, can appoint a director to make up the 2, because you must have 2. If you do not have 2 and the company operates for 4 weeks,
you're in breach.
With only 1 director, you are in breach. And I think 25 penalty units, which is about 300 Ghana cedis.
So it has to be done
quickly. It has to be done quickly, and then the company can continue. The point I'm making is that because of the separate legal personality principle of companies, the death of a shareholder, even if the only shareholder of the company, will not mark the end of the company. The death of 1 of 2 directors will not mark the end of the company. Even if all 2 directors die, the company, by resolution, can appoint other directors to continue. So there are no problems when it comes to limited liability companies as well.
Interesting thoughts there.
Yes.
A lot of information being shared. We want to get interactive. There's a lot more information, but we want to get interactive so that as the questions come in, we sort of skirt around and apply the information that we have. If you just tuned in, this is Masterclass here on your Superstation. Today we're sharing some very sensitive information on how to claim credit balances of a demised beloved one, should that happen to you. We know that many people go through that challenge. We're going to be getting interactive shortly. You can pick up the phone and give us a call and share your thoughts. I've seen a few hits on social media already, but we will take them when we come back from messages from our sponsors. We'll take a quick message. We'll be right back.
Your favorite on-air business development program, Joy Business Masterclass, is in session, and you can interact with us on Facebook, via the Joy99.7 FM or Joy Business pages. If you tweet, the handle is at Joy997 FM or at Joy Business GH. Don't forget to hashtag JB Masterclass. You can also call us on 0302 216541 or send your questions and contributions through to the WhatsApp number 0551 111997, and our facilitators will address your concerns. Attention everyone, class is in progress.
Welcome back. If you've just tuned in, this is Masterclass here on your Superstation. Today, we're having an interesting conversation on how to claim the credit balances of a beloved one should they pass or should they be deceased. Interesting thoughts there on the position of the law, what you can do, what you cannot do. Oftentimes, people complain and say, oh, my husband used to work with a certain man, or my wife used to work with a certain woman, and when he passed or when she passed, the friend took all the money. He's a bad man. He took all the estate. Sometimes we find out that it's actually the lawyers who are supposed to represent families who do this. Is it that we misunderstand the process? Is it that we don't understand the position of the law? Is it that we don't have information? Today here on the show, we're sharing some thoughts on this conversation. Executive Head of Retail Banking, Ghana Commercial Bank, John Adama, is here with me in the studio, and he's sharing some information which is critical. If you're driving, you can park because we want you to arrive alive, but by all means, do watch us on Facebook Live. We're streaming live. If you've got a motor vehicle of any kind, GOIL has some great news for you. GOIL is rewarding all its prepaying GO customers with 2% discount per litre on all fuel purchased. You also enjoy discounts on lubricants at GOIL stations nationwide. Elevate your goodness by joining the GOIL Go Club today and enjoy up to 3% discount on all fuel purchased. GOIL, good energy. GOIL, Yanara, Igedia. GCB also has some wonderful information for you. Masterclass today is also sponsored by GCB. So with a GCB personal loan, salaried workers can meet all the financial obligations with a smile as well. You have access to educational funds to deal with educational fees, urgent medical expenses, pop-up expenses and bills, home makeovers or renovations, or go on vacations or holiday with your family. GCB, your biggest and largest bank, makes life easy for you. So let GCB lend you the needed support for those urgent personal needs. Go for the GCB personal loan today. GCB, your bank for life. Phone lines are now open. We're interactive right now. Pick up the phone. Give us a call on 0302216541. That's 0302216541. Or send us a comment on 05511111997. We're also streaming live on Facebook, so by all means, do send your comments to us on Facebook, and we'll pick them up. The production crew will pick them up and try and pass them on to us in the studio. I've got a comment on WhatsApp. This one is from Stella from Boche. Stella says, my dad died in January 2013. The family went to his bank. It says into brackets, a commercial bank, for his money, only for us to be told that he took a loan in November 2014 and that they couldn't find his documents. That shows he was the one. So we ended up not getting anything from that account. I'm assuming your question is, what went wrong and how can that be prevented for another family if ever they go into that situation? This is Stella from Buche.
Yeah.
So let's use the scenarios and try and see if we can. Yes.
It's a bit strange because, well, it depends on the type of account the dad operated. And she was talking about documents in the custody of the bank. So I assume that this may be a secured facility that the father took. And it probably could even be a business account. And usually when customers take loans and they secure those loans with, let's say, some mortgage over landed property, and they finish paying, they do not follow through to go and discharge the mortgage. Yes. So
they pay the mortgage, but they haven't.
Yeah, they have paid. They have paid off, and once they have paid off, there are some customers who do not follow through, because you must. Once the mortgage has been executed, the bank's interest is entered, in the register.
Yeah.
And if you don't go and discharge it, that property is still encumbered
by a process of law.
Yes.
Hold that thought. Yeah.
Okay.
Go ahead, finish it.
Okay.
Finish
So they have to take steps. If indeed the dad had discharged his obligations under the contract, they can go and get the mortgage discharged. I'm just assuming that was
what the scenario was.
Yes.
I mean, we don't have all the details,
Exactly.
but we can only try and help.
Yes.
The thing is also this, that people don't disclose to their families. I mean, you can't tell your family everything, but you see, where there is no information, it makes it absolutely difficult for people posthumous to do anything. You know, I mean, terrible example that happened. A man actually mortgaged his home.
Yeah.
Didn't tell his family.
Yeah.
This one, he didn't pass. The bailiffs show up one morning and they are measuring the rooms because the house has been repossessed. And the children are screaming, "Daddy, what are these people doing in our home?" You don't want to put your family through that. This one is from Ajingo the Man, Ajiman Joseph, Committee 9. It says, "Good afternoon, Masterclass. Please ask for me. If a partner in a business who is also a signatory to the joint account is at the emergency ward and the company also needs money urgently, what will the partner do?" I'm assuming, what will the other partner do? Not the one in the ward.
He's a signatory.
He's
a signatory to the joint account.
Yes.
So so once again, let's draw the distinction. A partnership account is not the same as a joint account. So if it is a partnership account, then that partner is a signatory in the partnership. I mean, on the partnership account, not the joint account. So in this case, he has not also stated whether he is the only signatory. And as I've indicated, if it's a partnership and this sick person cannot give instructions, a partnership is not the same as the individual. So the partnership itself can take steps to give the bank a fresh mandate and the account can continue to be operated.
Okay. But assuming it were a joint account.
Yeah, if it were
because that's the example we gave at
yes,
first.
if it were a joint account, then once again the mandate will come into play. Is it either to sign or is it both
so if
to
it's
sign?
both to sign, I
Yes,
think that's
if
where
it
he's
is
going.
yes, if it is both to sign,
Where one is incapacitated.
then of course if one is incapacitated, it depends on the type of incapacitation again. If it is mental,
he can't sign.
He simply cannot sign.
Yeah.
I mean, these are issues that bankers are able to handle with their customers
On a case-by-case basis.
case by case basis. Sometimes we even follow through to wherever they are.
Okay.
I mean, or put through calls if we have to seek help from the medical officer that are taking care of the people, and we sort these things
So
out.
Ajiman Joseph, it's handled on a case-by-case basis,
Yeah.
but in any case, your bank should be able to help you, depending on what your situation. This one is from Nav from Spintex. It's a great topic. I'm really being educated. So when an account holder dies, does the partner or related persons have to have discussions with a lawyer to know all the processes to take, or the bank is the one who advises them when they're approached? This is Nav from Spintex.
Yeah, it's you have to get a lawyer. You have to get a lawyer. If you go to your branch manager with your problem, your branch manager will advise that you seek help from a lawyer. Yeah, if you are sick, if you have toothache, I'm sure you know where to go to.
Of course.
Yes.
Of course. I think I've got a caller on the line. Let's put that call through now. Good afternoon. You're welcome to Masterclass. Your name and where you're calling from.
Good afternoon.
Good afternoon,
my name is Rukaya. I'm calling from Hachu.
Sorry, I missed your name there.
The name is Rukaya.
Oh, Rukaya, how are you,
Yes.
my dear?
I'm blessed. Yourself?
I'm good. Talk to me.
Okay, so I want to ask, if it's a joint account and then quite unfortunately, both partners pass on, what happens to the account?
Okay. Please keep listening. We'll try and answer
That's
that.
an interesting one. That's a very interesting one. If you look at, I think Section 34 of our Evidence Act, there is a concept, the doctrine of comorientis, where you can have two persons die under circumstances when it is difficult to even know who died first. So like what Rukaya is saying, so two parties to a joint account, let's say they die in an accident. You are unable to tell, because joint accounts are operated on the principle that the credit balance on the account devolves to the survivor.
So if there's no survivor,
so the two of them have died. You know what our laws say? The two of them that have died, one of them is older than the other.
because one died first.
One died first. It will be presumed. It's a presumption.
Yeah.
Unless, of course, there is a rebuttable evidence. There is a presumption that the old died before the young. So the personal representatives of the young are the ones that will inherit.
And it's a position of law.
Yes.
There's no arguments there.
Yeah, that is law.
This one is from Ajua Mimi on Facebook. Ajua says, what happens in the case of a savings account when the account holder dies? How does a family access funds from that account?
Yes, I think that's where we are going to next. I mean, the processes. I don't know whether...
Unfortunately, we're running out of time, so we may have to... I'll talk we'll see if my producer can allow us to have this conversation next week.
Okay.
But we can try and answer the question,
yes.
I suppose. With
So it depends on whether the person died testate or intestate.
Okay.
Testate means he wrote a will
before
dying. Intestate means that he died without a will.
If he died testate, then
there's a will.
But if he died intestate,
it means that he hasn't written a will.
Yeah.
He died without a will. So if he died testate, then the personal representatives are executors of the will, and they are appointed by the deceased himself in the will. So they would have to admit the will to probate. They would have to obtain probate from the courts. And then on the strength of that probate, they can administer the estate. And the estate includes the bank balance.
Right. But if he died
intestate, then the personal representatives would be administrators. Okay. And the law provides, if you look at the Interstate Succession Law, you look at the Administration of Estates Act, Section 77, it provides that the number of persons that can, or the categories of persons that can apply for letters of administration.
Right.
So if there is a spouse, the spouse will be there, children, if there are parents, and then the customary successor, they would have to make an application to the court.
Okay.
And the court would grant them letters of
determine the
administration.
process.
Yes.
Okay, so I mean, either ways, there's a process.
There's a process.
If he died testate, there's a process to go through. If he died intestate, also there's a process to go through. But either ways, you can have access to the funds. I suppose when people ask that question, it's not so much of the access; it's how quickly. Because that's where the frustration comes in. But it is what it is. You have to go through the processes.
Exactly.
You have to go through the processes.
Yeah.
Okay. Just remind us that today's show, Masterclass, is sponsored by GCB Bank. I'll be corrected here severally, and even on Facebook. GCB Bank. I've got Gordon on Facebook. Gordon says, my father died more than 12 years ago. He was a shareholder in GCB Bank. Any advice on that? My advice is go to GCB Bank, right?
Yes, it depends on whether the dividends are being paid and if they are being paid into what account. So it should. I think we have a share registry that handles this in GCB share registry.
Is there a particular location he could go to?
Yes, they are. I think on the first floor of the head office block.
First floor head office block. Yeah. Gordon, go there and speak to someone at GCB.
Yeah, they will assist you.
They can assist you. Isaac Dako Asari on Facebook says, can two legal entities enter into a partnership and open account for the new entity, or that arrangement becomes a joint venture?
It's a joint venture. In fact, that was right. That's a joint venture.
Said
a partnership in individuals.
Okay.
Yeah.
I think I can squeeze in one more phone call. Numbers to call 0302216541, or you can send us again your comments on 0551111997. While we're waiting for the phone lines to ring, perhaps you can slip in a few more.
Yes. So I think the points really I wanted to make were about the death testate and the death intestate. And then the processes that so you will need to obtain the letters of administration, and you would have to send an original copy of the probate or letters of administration to the bank. The bank would want to see the original because people could be holding on to certified true copies when in actual fact there is a citation that has been filed and the originals have been deposited at the registry of the courts.
Right. I've got this one from Bawe. It's from KK That. It says, my father went blind before his death in 2015. He introduced my sister and I to the bank to transact on his behalf, and I was acknowledged by a letter and physical presentation. After his death, a new manager refused the arrangement.
Yes. So I don't know what kind of arrangement that was. I don't know whether they were appointed as receivers. Or it was through a power of attorney.
So speak to a lawyer. Share the details.
Death actually, if it's a power of attorney, death would terminate that power of attorney.
Right.
Oh yes.
So if it was a power of attorney.
If it was a power of attorney, and I'm sure that was what they were operating with.
So for you to be satisfied, Mr. Datson, get a lawyer, speak to a lawyer for advice, and share all the details with him, and I'm sure he'll be able to give you. This one is a fear. You didn't tell me where you are calling from. It says, what is the starting point process of getting monies of a dead mother who was a pensioner from SNIT and her local bank? Yeah, please ask him for me. Again, is there a limited age for SNIT And if there is, which age, please?
But I think this is in the domain of SNIT.
For SNIT?
Yes. If the money is in the bank account, we can assist.
Right.
But as for the issues of SNIT, I think
here's what we'll do for you. We'll take note of that question, and then we'll try and get some answers for you. And then we'll try, when next we come on the show, we'll try and have that answer for you. This one says, hello, yeah, what happens from the perspective of the bank? No one is aware that the deceased operated that account and there's credit balance on that account. Okay, it's not very clear. He says, what happens from the perspective of the bank if no one from the deceased family knew about the account and there's credit balance?
I'm sure they are aware of the Bank of Ghana unclaimed balances and dormant account policy.
Yeah, it goes back to BOG, right?
Eventually, we'll have to do something about that.
So it goes back to the BOG.
They would have to take steps to, trace the money.
People are very unhappy about that thing. But
that is the law, to be honest.
Well, the law is the law.
Yeah.
Okay, I think I have one more comment here. This one is from Seydou Samad. Okay. Can a family member claim the deceased's funds without the person being the next of kin?
So once again, there are categories of people who can be granted letters of administration or probate. They are the only ones that can lay claim. And the court would have to satisfy itself that you belong to that class.
Right.
Yes.
Unfortunately, we ran out of time. What's our takeout from today? If we're able to have this conversation again, then we'll share some more information.
Yeah.
But otherwise, what should we remember from our conversation today?
Yes, what we should remember is that when a customer dies, leaving credit balances in the bank, those balances are claimable. And but I think what I will leave with the listening audience and the viewing audience is that we should try to develop the habit of opening joint accounts so that
people don't like joint accounts.
Yes,
but if you are listening, please.
Yes, open some joint accounts, leave some money in there, and then we should also try to update our account information with our next of kins. The contact numbers, our own contact numbers, up-to-date account contact numbers, and then the contact numbers of our next of kin. Because now with the dormant account policy, banks are reaching out to get customers to come and reactivate their dormant balances. And it is becoming difficult because the contact numbers are not in the system. So we should all strive to do that, bring the information up to date, and then when we die, we will not leave our balances in the bank.
Thank you so much. Hopefully we can become better and we'll prevent some of these things from happening. This has been an exciting conversation. I do wish that we have the opportunity to continue and share, because we had a lot of information which we were unable to share. But next week we continue with our conversation with GCB, and we'll have the privilege of sitting with Mr. Ronald Marty, who's the Chief Information Security Officer of GCB. He will be taking us through the 10 things that organizations can do to stay protected in the digital age. This has been Masterclass here on the Superstation. A big thanks to Mr. John Adama for taking the time out, Executive Head Retail Banking GCB, to share these thoughts with us. We continue with the Ignition up next. My name, as always, is Barnafo. See you same time next week.